Welcome back. You're watching HFO-TV.
Hi, welcome back to HFO-TV. I'm Greg Frick, partner at HFO Investment Real Estate. Thanks for joining us again. Today we have the privilege of speaking with Andy Hahs, partner and founder of Bittner and Hahs PC. They're a law firm that's done a lot of things in the tenant landlord legal arena in the state of Oregon. I've known Andy for 20 years and have done, I don't want to say he's represented us multiple times, but we've had a lot of clients who've worked with him a lot of times. So we're going to talk a little bit today about kind of the legislative update. We had House Bill 2004, and we also have the City of Portland Ordinance regarding relocation fees. So again, thank you for coming, and thank you, Andy.
Glad to be here.
Maybe you can give us a little background of kind of your history in terms of landlord-tenant law before we kind of get into the specifics of these things that are on the table in Portland. And
I started representing landlords back in the mid-1980s, doing mostly transactional work for the management companies and their management stuff. And then about 1990, I was asked to start learning the landlord-tenant stuff and started doing representing landlords in the residential area, and was there when we started Multifamily Northwest, and was a founding member of that, and got to know everybody through that, and have been, basically representing landlords ever since the early 1990s.
And things have changed a lot since the 1980s and 90s in terms of landlord-tenant law.
Oh, every 2 years it changes, yes. It used to be that we would sit down and have a good negotiation with the tenants, and it would just be minor changes to tweak the law. In the last couple of years, it's been very radical type changes being proposed by the tenants and being opposed by the landlords. And then this year was the first year we haven't had a landlord-tenant coalition, because the tenants just wanted to talk about getting rid of no-cause notices.
So maybe we can talk about that. I'm sure a lot of people already know that we had House Bill 2004 brought by the Speaker of the Oregon House, Tina Kotek, in regards to no-cause notices and rent control. A lot of discussion. I mean, there's been a lot of talk on both sides. Maybe you can give a little update on kind of what happened there and where we stand today.
Originally started in the House. It passed with almost no changes from what the Speaker had proposed. It was getting rid of the preemption on rent control. In Oregon, we have a preemption that says no local agencies or jurisdictions can do rent control, and so they wanted to get rid of that so that the cities could start doing it. And then they had very restrictions on no-cause notices. They allowed it in very limited circumstances, but they'd have to pay relocation, and there were a lot of restrictions on that. And that was the original bill that came out and passed through the House. It went over to the Senate, and there were a number of amendments that were proposed there. And the biggest one was it got rid, or it kept the rent control preemption in place, and then it broadened what you could do for no cause. After a lot of debate, it actually failed in the Senate, and we were able to defeat that.
The bill completely. The
bill completely. Nothing passed out of the legislature, but we expect that to come back either in the short session in 2018 or in the full session again in 2019.
Right. In some kind of form. Maybe they'll break it up, maybe they won't. I mean, that was kind of, yes.
Right. Speaker Kotek has indicated she really wants to pass as much as possible. The Senate has been more reasonable in their approach to it, trying to address specific concerns instead of just doing a broad blast.
And historically, in your experience, it's always a lot of these landlord-tenant law topics have been dealt with in a coalition, where you had the landlords and the tenant advocate groups working together and then bringing stuff to the House and Senate, but that wasn't the case on this one.
That's correct. The coalition has been a very successful thing over the years because it gives time for the advocates for both sides to talk through it and actually negotiate changes that make sense. And we've come to the legislature with a fully vetted bill that both sides have agreed to. This year it was just tenants saying, we want this, that got passed. Landlords going, we don't want that, and there was really no basis or grounds or ability to negotiate. We're hoping that the coalition will happen again going forward so that we can actually have that opportunity to have a good conversation and a good vetting.
And which leads me into what's going on in Portland with the relocation fees in Portland, which got passed, I think that was in March of this year?
It was February of this year.
February this year. Yep. First there was the housing emergency, and now this kind of runs on top of that. Supposedly it's going to expire in October, but they can re-up the state of emergency for housing and can run this thing through.
That's correct. So back in 2015, they declared the emergency. They imposed a 90-day requirement for rent increases of 5% or more. and a 90-day requirement for any no-cause notices. In 2017, this year in February, they added the relocation assistance requirement payments. If you do any sort of a no-cause termination, you have to pay the relocation. If you do rent increases of 10% or more in a 12-month period, you have to pay the relocation assistance.
And again, that's just in the city of Portland for people that aren't sure. It's just the city of Portland. This is not a statewide. It's a city of Portland only.
That's correct.
Okay.
But we're expecting other cities. There was a lawsuit that was filed challenging it, and the trial court judge ruled recently that the ordinance was valid, 100% valid. We would expect other cities to look into that and start enacting things similar.
Right. I know they're in the process of probably going to appeal that, but the idea was running counter to what the state regulation was, and the city kind of went on their own.
That's correct. One of the biggest challenges was to the rent increase as a form of rent control, which it really is. You can't, if you're going to go 10% or more and the tenant decides to move, then you have to pay the relocation, which we think is a significant type of rent control.
Right. And then kind of bringing back to the coalition, kind of the example I was trying to think of was in terms of, it felt like the city of Portland did not have a lot of input from, both sides, because just even some of the, if you agree or disagree with the relocation fee, just the nuances of how the law or how it was put in from an operational standpoint just doesn't make a lot of sense. Maybe you can enlighten a little bit on that.
Yeah, so it passed with really zero input from the landlords. And in fact, I understand that Commissioner Udaley said in open session, we didn't want input from the landlords.
Right.
So they passed, it was like zero prior knowledge of this. It came out, it was passed, and then part of the commission, they voted to say we need a task force now to look at the law, now that it's in effect, and deal with the unintended consequences. We actually got some representation on that, and they came out with a report that had like 20 pages of unintended consequences from this ordinance with a whole list of recommended changes. The City Council passed some amendments about 3 weeks ago, virtually ignoring what the task force had suggested. There were a couple of very minor changes that came from the task force, but then Commissioner Udaley's office proposed another amendment that had never been talked about at all on how relocation was paid when there was a rent increase of 10% or more, and radically changed the ordinance.
So within the city of Portland, they passed the ordinance, so now it's kind of in place, but they continue to kind of work on the nuances of how it's going to be implemented, but it's already in, it's in practice now.
Yeah,
Yeah.
They passed it in February,
Right.
and they made it effective immediately.
Right.
So even
I
with
remember that, yes.
even notices that were in place,
Yes.
and rent increases that were already in place were affected by it.
Yeah, I think you had a 14-day, as a landlord, you could rescind it within 14 days if you had a notice out. Yes.
Yeah, there were some very minor transition rules, but they weren't very effective.
Right, right.
Yeah.
So maybe you can enlighten us a little bit on maybe some of the nuances of the changes that are in place or where this may be going.
Well, the biggest change had to do with what you do with a rent increase. So originally it was passed that if the landlord did a rent increase of 10% or more in a 12-month period, then the tenant had 14 days to notify the landlord that they were going to leave. And if they elected to leave, then the landlord had to pay them the relocation assistance.
Right.
That was completely changed, and now it is, if the landlord does a rent increase of 10% or more, the tenant has 45 days to notify the landlord that they would just want to get paid. They don't have to elect to leave or not, they just say, I want to get paid.
So you raise the rent 10%.
Or more, right.
Or more. And it used to be you had the tenant had to give you notice that, hey, I'm going to move,
Right.
and you owe them a relocation. Now
Yes.
you give them 10%. They just have to give you notice in 45 days, I want to get paid.
I want to get paid, and then the landlord has to pay the tenant, and then within 6 months after that, the tenant can say, oh, I decided to stay, in which event they're supposed to pay back the relocation assistance, or they say, I'm going to leave, in which event they get to keep the relocation assistance. But if they don't pay it back, there's no penalty for the tenant. They're just in violation of the ordinance. But that doesn't give you a right to evict the tenant for that.
Right, because it's not like behind on rent. This is a different
thing. It's
Right.
because there's nothing, it's a violation of the ordinance, but not necessarily a violation of the landlord-tenant law or the lease. So you want to make sure your rental agreement specifically says that they have to comply with all laws, because then if they violate the ordinance,
Then you're throwing that in there.
Then that throws and gives you the right to at least do a for-cause notice to get them out, but that still doesn't get you your money back. And if you sue them to try to get your money back, there's no attorney's fees for you. It's a one-sided attorney fee provision. Because if the landlord messes up and does the wrong number of days, doesn't pay on the right time, then the tenant is entitled to a penalty of up to 3 months worth of rent, plus the relocation, plus attorney's fees. But if the tenant loses,
Right.
the landlord doesn't get their attorney's fees.
Is that typical on landlord-tenant law where the attorney fees is a one-sided type of arrangement where it's, the tenant's, entitled to attorney fees, the landlord's not?
No, that is totally different than the landlord-tenant law. And the other difference is the amount of the penalty. In the state landlord-tenant law, there are some penalty provisions, but the biggest one is like 2 times the rent, and that's for intentional retaliation.
Right.
So it's got to be an intentional act. There's 1 month worth of penalty for a wrongful entry, but most of them are a couple $100s. And so this is the biggest penalty for violation of any sort of landlord-tenant law, and you don't have to know you're even doing it. You count the number of days wrong, you're day late on the check, you can be
Right,
subject to
it's
this
not like
penalty.
intentionally like a, retaliation or something like that where you even, wow,
Yes.
that's a big penalty.
It's a big penalty, and now other cities are starting to pick up the same penalty, because after that penalty was in the original ordinance that was passed in 2015.
Okay.
Milwaukee passed a similar ordinance on 90-day notices for no-cause notices, and they picked up the same penalty. So once it's out there, it's sort of like Portland's the tail wagging the dog.
Right.
Once they do something, everybody thinks, oh, that's the way to do it.
So and has it gone through this way, or this is still negotiations in terms of the changing of with the tenant having this 45-day notice to come back? I mean, the city's still kind of working through the nuances of that?
No, this passed.
That's
This passed
passed.
about 3 weeks
That's the
ago.
one that's passed. Got
Again,
it.
without this particular change was not anything that had been discussed in the
Right.
task force at all. Again, they don't want input from, my view is anyways, they don't want input from the landlords, they just want to do what they want to do.
So now in place in the city of Portland is you give a rent increase, they've got notice, they've got 45 days to say yay or nay, I'm going to leave or not. You've got to, and it's, again, you're giving a rent increase with a 90-day notice because we're, the way it was set before. Tenant says 45 days, yay or nay. If they say I want my money, you got to pay them the money, and then they've got another 6 months to figure out if they're going to stay or leave.
Correct.
Interesting. Well,
Yeah.
that's going to make things quite. Now, is this retroactive too with existing notices?
It was effective immediately, so
Again.
it probably applies to outstanding notices at the time. Yeah, and you got to be really careful about the rent increases too, because you can go over the 10% unknowingly.
Right.
And things like if the tenant comes to you, say in January, and says, I want a dog, and you go, okay, you can have a dog, but there's pet rent for the dog.
Which is normal in this
Which
market.
is normal and
Yes.
typical, and
Yes.
that's all okay. And then in June, you're going to have your renewal of your lease, and so you raise it 9%, but you forget about the dog increase. So now you've got more than 10% in a 12-month period. It triggers the ordinance even.
Because the dog rent, the pet rent is included in there. It's inclusive.
Is inclusive in the rolling 12-month period, yes. So you give them they want a garage, so you have garage rent. Now you may be limited in what you can charge an increase in their regular rent because you've already got that increase,
Right.
even though it was something the tenant wanted. And they're asking for it. The tenant goes, I'll take a dog, yes, I'll pay you extra money, but now it limits what the landlord can charge because of the way the ordinance is written.
And are utility rubs included in? Are those factored in, or is that something on the side? When
That's to the side. So
Okay.
if you impose a new utility charge, that
Right.
can go in towards it. But if it's just the utility rubs that
Could fluctuate.
fluctuates normally, that is excluded.
And what about utility rubs that are flat, where it's a one bedroom's paying 49 and a 2 bedroom's paying 69? Is that going to be included in?
That is a question.
That's a
One of
question
those
itself.
questions,
Got
yes. It may not be considered rent for the 10%, but it is considered an increase in housing costs for purposes of how long and what kind of notice you have to give. So it's really nuanced as to the 10% rent increase is what triggers the relocation
Right.
assistance. And rent is different than housing costs, which may include things like that. So if you just increase the flat amount of utility pass-through, that's not a RUBS that's going to be fluctuating.
Right.
So it's outside of the clear exception.
So
of
they
the-
could
of the
put it in
ordinance.
there.
They could put it in there, yes.
You might be real busy here the next year.
We have been very busy, I got to
Yes.
tell you that, yes.
Wow.
Not in a good way.
And then any other, I mean, I know you've been involved in some of these. Is anything else that's on the board or on the horizon maybe from the city? I know not say we, but I know the industry's been felt a little excluded from terms of hearing it. Even, as I said to somebody, even if you agree or disagree on the 10% of the relocation fee, just from a logistics standpoint, it would be nice to have property managers and owners involved just to say, this is how the business works, this is how we run. You know, it's almost like they don't even hear that at all.
Well, they have recently adopted this Office of Renters and Owners Services.
Right.
And they are going to have an advisory board for that, which I understand is going to be a majority tenant advocates.
Okay.
Some landlord representation, but we don't know who's going to be on that. And we don't even know exactly what this office is going to do, whether it's going to be simply advocates or whether they're, we don't know. But there has been some talk of in October, when the housing emergency supposedly expires, what's going to happen. And one of the talk is that I understand is there's some idea that they'll try to go with a new relocation that's more like the city of Seattle,
okay,
which is actually a needs-based and income-based on the tenant, so it's not everybody, and it's not a set amount for everybody depending on...
It's based on the tenant's ability.
It's based on the tenant's needs, and it's a much fairer system. Whether that'll happen or not, I don't know. My personal feeling is there's no chance that they're going to just let it expire.
In October. This is the housing state of emergency, which kind of triggers a lot, not triggers, but as long as that's in place, these changes are tied to it. But
they're tied to it now, but they
Right.
can simply say there's no more emergency, but this is a permanent ordinance. Right. So they can do that. So in my view, there's no end to this, whether it's going to be in this form or some other form. But I think my best guess is that Commissioner Udaley is very, she's in favor of this, and this is going to stay in place unless something radically changes.
Right. Like I said, there's pending, there was litigation brought against the city, and there, maybe appealed, and we'll see what happens there. But
right.
Yeah, and you said other cities now are kind of looking at Portland and saying if they're able to get that in, maybe we can do something similar.
Exactly. I'm thinking, because one of my partners does a lot of work with the city of Wilsonville.
Right.
And there has been a big push in their city commission to enact something like it, but they've been waiting because of the litigation.
Gotcha.
Now that the litigation's been decided, at least at the trial level, they may go with something, whether it's going to be something like this or something different. The trouble is that a lot of other cities they just go, well, we'll just take this and we'll mirror it. And
yeah, it's easy.
It's easy, right, exactly. And this is really bad, so it'll get spread.
Well, it's almost like they assume
virus.
it's been vetted out. And you're like, well, no, it really hasn't been vetted out. The logistics of it have not been vetted out. But like you said, somebody just runs it through, and yes.
It's easy, right?
Right. Now, could the state put something in place like this, or is landlord-tenant law, on the state side? I mean, how much control can the city have on landlord-tenant law in terms of, it just has to make sure it stays within the confines of what's in the state?
Well, there's a clear prohibition on rent control.
Right.
I mean, that's the one that simply says no local jurisdictions can do rent control. The rest of it is a question of how far the local jurisdiction can bend the rules. Like if they said there are no cause notices allowed, that would probably be a violation of state law because state law allows no cause notices.
Okay.
So a clear prohibition would probably go against state law, but they can, put costs on it, they can put different time limits on it, they can do different requirements. And that's what the judge said in his decision, is that putting a cost on doing a no cause notice doesn't violate state law.
Right. Got it. And when they do when a city did a housing state of emergency, does that enable them to be more aggressive, or is it just more of we can do this and we can make some changes and kind of tie it to it just to kind of get it in the door, and then we'll see what happens once it's in?
I think so. I'm not aware of any legal requirement that there be a housing emergency before they start enacting this stuff. I mean, they can probably just do it based upon
whatever
do it. I think it's a good political cover because they said, oh, it's just temporary, but we know a lot of laws that have been temporary for 50 years.
That end up being permanent. Yes,
Yes.
Exactly. Well, it's going to be very exciting, I guess, in the next couple of months. We'll see what happens with the appeal to the city. As we've talked about privately, I think, what happened, there was kind of a win in the state in defeating 2004. I don't think that's the end of it. I think it's kind of the start of kind of moving forward. Just seems the tenor in terms of landlord-tenant law, the pendulum is really far to one side. We kind of try to talk about supply and bringing more units online, and it feels as if it's getting kind of on deaf ears a little bit. I mean, on one side you want to do inclusionary zoning to increase the ability to have affordable housing, but then on the next side you want to put in these rent control and things like this, which are going to limit supply. People aren't going to have to build, so then you don't get the benefit of inclusionary zoning. It's almost a disjointed kind of policy towards addressing this, housing state of emergency, they like to say.
It is, and the tenant advocates, when I listen to them, it's almost like they want to punish landlords.
Yes.
And they're not open to a discussion about how do you solve the problem, because getting rid of no-cause notices and putting it on rent control doesn't do anything to solve the problem.
Right.
As we've talked about it, it's really supply.
Yes.
And I saw a recent study from the National Housing Council or something where they identified how to increase supply, and most of those things are no cost, just administrative changes that the city can implement and make things a lot more affordable. But everything they're doing is increasing the cost of the landlord.
And the cost of developer.
And the cost of the developer.
Right.
And so that has to go somewhere. It's going to get passed through in some form. So they want to increase the cost to build and impose rent control, which we know is going to do great things for supply.
Right, exactly. Well, it's a kind of an issue we've had. It's that NIMBYism here, not in my backyard. It's, I'm here, I've got my little piece, I don't want it to change. And as I said, if somebody asked me who's not even involved in the industry about, raising rents, so, what do you do to the person that you have to raise their rents? I said, well, I understand that, but then what do you say to the 20 people that are moving into the city? Where are they going to live? You're not building more units. You have people that want to live here because it's a great place to live. Where are you going to house them? And I think it's kind of I just sometimes think the politicians don't really want to listen to that because it's not a really good story.
Right.
And then you seem like we're banging our head against the wall a little bit. So
it is, and the politicians don't want to take any responsibility for making things worse.
Right.
I mean, the urban growth boundary is a great thing when you want to go bike riding out in the country, but when you want to build stuff and the cost of land, as you see all the time, is so high, somebody's got to have to pay for that or it's not going to get built.
Well, and somebody asked me kind of what a tipping point was in Portland. I think of some of the tenant stuff. I think the other one was when the city got called out on the amount of low-cost or affordable housing that was supposed to be built in some of these economic redevelopment zones, where they had made the plan that, we're going to do the Pearl District, we're going to do South Waterfront, there's going to be X number of units. Of the 3,000 units, so many are going to be affordable. They never kept track of it, and they got called out on it about 10 years later and woefully short of the number they promised. So now it's almost like they're trying to do catch up with a punishment to the people that are providing housing, which again doesn't make a lot of sense economically, but I think we've been in these arguments before with them.
Right, they don't want to listen to economic arguments.
Yes, that is true. Well, thank you for coming. It was very enlightening. We'll see you again next time on HFO-TV. Thanks, Andy. That was good.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.